crime in the Northern Territory has been a concern for quite some time now. We need only look at the latest news from Alice Springs to see entirely the problem. Nary a day goes by without a fresh stabbing or a robbery or something else going wrong. Alice Springs is a trash fire, literally. But now even the judges have gotten sick of it. They've gotten sick, seemingly, of the merry-go-round of people coming in and out of court, and of the victims seemingly coming back in as victims in fresh crimes. Indeed, the judges, who seemingly to my mind might have been a little bit soft on these types of things, are losing patience. Case in point is the Northern Territory Chief Justice. He's focused attention on the subset of crime committed by Indigenous Australians. He's noted, for example, that 93% of domestic violence victims are Indigenous women, a startling statistic. Now, of course, there can be underreporting of domestic violence. People might not go to the police for various reasons. However, unless you believe that underreporting is significantly less prevalent amongst Indigenous women as compared to, say, non-Indigenous women, well, it's telling us that there's a bit of an issue. Furthermore, 90% of the attacks on Indigenous women are alcohol-related. The Chief Justice also called out sham justifications for violence, including alleged justifications under customary or traditional law. He's noted that such justifications are often complete BS. His comments were so pertinent that it's worth watching them for yourself. And here's a clip that I've sourced from The Australian.
Traditional laws provide no general authorisation for intimate partner violence. So it's not as if anything goes. As one Indigenous commentator observed, there are now three kinds of violence in Aboriginal communities: alcoholic violence, violence in accordance with traditional law, and bullshit traditional violence. What that last category is intended to describe is the sort of assault that's perpetrated usually, if not exclusively, by drunken men for illegitimate reasons, which is then sought to be justified as the exercise or enforcement of some sort of traditional right. And of course, that's also a problem that presents in communities where there is some cultural tolerance for a degree of violence in a legitimate sense. The breakdown in traditional law in Aboriginal communities is no doubt associated with a growth in intimate partner violence, an increase in the incidence of it. Alcohol abuse is, as I've said, a contributing factor and probably the principal operative factor in that breakdown and that growth. Customary laws have never sanctioned indiscriminate violence. There have always been, even in laws which did tolerate certain forms of violence for certain purposes, clear distinctions between good behaviour and bad behaviour, and discipline. That particular discipline was always strictly maintained by the elders. There are various reasons to do with breakdown in traditional law, which means that in some communities that rigid enforcement is no longer possible. Intimate partner violence is by far the largest subset of domestic violence or family violence in the Northern Territory. While this is obviously not an issue which is confined to Indigenous communities, it is of particular concern in that context and in those communities. And the statistics bear that out starkly. The coronial inquest, which was recently conducted in this jurisdiction, identified that 93% of the victims of intimate partner homicide in the last 25 years in the Northern Territory have been Aboriginal women. The rate of intimate partner homicide in the Northern Territory is 7 times the national average. Aboriginal women in the Northern Territory are 40 times more likely to be hospitalised as a result of intimate partner violence than other members of the community.
Now, clearly, there's a few things to note. First, it appears there is too much crime per se. Whether it's perpetrated by Indigenous Australians or other people, there's simply too much crime. Victoria shows us that not all crime is by Indigenous Australians, and indeed much violent crime is not by Indigenous Australians. However, there's also a problem with crime amongst Indigenous communities. If 93% of all domestic violence victims are Indigenous women, then it's telling. And you cannot tell me that prosecuting someone for battering their domestic partner is a display of over-policing or discrimination against that perpetrator. If you've beaten up your wife or your girlfriend, then clearly you do deserve to be prosecuted. Second, alcohol appears to relate to some of it. Very clearly, we need people to have a more constructive relationship with alcohol rather than abusing it and then going all the way off the rails. Third, there's the issue with customary law, which certain law faculties now seem to lionize and seem to believe is the solution, or at least a guiding path. For example, I was recently taking a course to obtain my law practicing certificate. One of the presenters commented favourably on traditional or customary law. The presenter noted that when a perpetrator is punished with lashes or strikes, then allegedly the victim would also receive the same number of strikes so that no resentment would percolate. Now this is clearly absurd. Firstly, there's clearly violence which shouldn't be in the criminal justice system, but that notwithstanding, the victim has now been re-victimized by the justice system that was supposed to protect them. Now whether or not I ever actually practice law, and at this point it is doubtful, the anecdote gives us some insight into the present state of education, and also gives us some insight into why it is we really should be departing from traditional or customary legal practices. This is an issue. The Chief Justice stated that, quote, "As one Indigenous commentator observed, there are now three kinds of violence in Aboriginal communities: alcoholic violence, violence in accordance with traditional law, and bullshit traditional violence." To which I actually want to focus on that second category, violence in accordance with traditional law. I'm sorry, but how is that justifiable or in any way seen as okay? Surely, we should defend the victim of such violence. We seem to be going out of our way to try to defend the perpetrator, but if someone is the victim of violence that is supposedly in accordance with traditional law, they're still a victim of violent crime, and they should still be defended in accordance with the law that Australians are supposed to be protected by. Why should an Aboriginal person have to suffer violence merely because they are Aboriginal and we deem them to be subject to customary or traditional law? Why should they have to put up with things that we wouldn't put up with? It's clearly actually discriminatory in the way that actually makes life worse for many Indigenous Australians by forcing them to put up with that type of violence and that type of customary law, which, as I've indicated, is something that other people would simply not tolerate. If customary or traditional law permits violence that we would deem to be cruel, unusual, arbitrary, capricious, or unsatisfactory in any other way, then that customary law must be discarded. Why is it that an Indigenous Australian should be subject to that type of law? Clearly, our laws should be protecting them as well. The law should serve to protect victims of what would otherwise be a clearly criminal act. A hypothetical example that I find particularly troubling is one that Chief Justice Grant cites. He said that in arson cases in Aboriginal communities, they frequently involved jealousing. Now, jealousing appears to involve an idea of two people being jealous of a particular good or potentially jealous of a domestic partner. So he says, and I quote, "A community elder, for example, might decide to burn a motor vehicle, which is causing arguments amongst relatives of the elder's family about the use of that motor vehicle and who's entitled to the use of that motor vehicle. And stopping that form of jealousing about the item of personal property is considered by the elder to be preferable to maintaining the use and frequently trying to work out the equitable sharing of it." So basically what we see here is somehow it is seen as an appropriate solution to burn a vehicle rather than working out who the rightful owner or the rightful user of that vehicle is. That's truly insane. Clearly we should be protecting the property rights of the rightful owner, not burning something because a potential thief is jealous of it. That's obviously absurd. I'm sorry, it just is. You should protect the person who owns the motor vehicle, not just burn it because a thief feels themselves entitled to it and is in conflict with their intended victim. Where would it stop otherwise? Do you burn down someone's house because someone else wants to occupy it? If Purple Pingers, for example, in Victoria, says you go and squat in someone's house and you don't want them to squat in your house, would we just burn the house down because someone is jealous of it? It's clearly ridiculous. But in any case, that's an example that the Chief Justice cites, and to my mind is an example of how that jealousing idea should be put to the side. And I also regard this as an example of how that type of traditional law or traditional rule, assuming it is actually applied as the way the Chief Justice states, is going to lead to people being discriminated against and will lead to people being victimized by laws that are actually supposed to protect them. And in any case, we very clearly have a crime problem. The merry-go-round of incarceration might not help, of course, but we must protect victims of crime. They should be the ones that we are actually focused on. We should be focused on preventing people from being the victim of violent crime in particular. And if that means that someone needs to be blocked up, then so be it. The victims are the ones who we actually should be standing up for. Now, of course, the solution could be additionally to focus on rehabilitation while the person is incarcerated, so as to reduce the incidence of recidivism when the person gets out of jail. However, we must protect the victims first and foremost. For example, as Victoria shows, simply turning a blind eye to violence merely worsens the problem. Victoria has gone down the death spiral of accepting violent crime. But of course, you can let me know your thoughts about the situation in the comments below. Do you think that crime is out of control in the Northern Territory? Or do you think people are just making a mountain out of a molehill? Let me know your thoughts in the comments below.